afternoon and welcome to the latest in our residential property forums. I'm Robert Kelly from Stewart Title, and once again we're joined by Ian Quayle of IQ Legal Training to talk about interesting topics. I was just looking at the calendar on the screen before we came on, Ian. It's only two months till Christmas.
Oh gosh.
So
are you gonna what's do you want my list now or shall I send it afterwards?
Well, I'm looking forward to my BSA annual and Lego kit, because I think that's going to be the big one for this year, is to build your own 11-story building or whatever.
It's massive.
Yeah. And on that, Ian and I have been talking. We hopefully in November we'll have another session on the BSA because it does keep on changing, and we will be joined by someone from the Levelling Up department who's going to explain to you that it's all very simple. And frankly, you should have understood it right at the beginning. But we'll send you some more details on that in time. But Ian, if you're ready, then let's start.
Thanks very much. Thank you, Robert, and good afternoon, everyone. Again, as usual, a massive thank you for Stewart Title for organising these events and for sponsoring them. It's really good. In November, the forum will be sort of BSA related. I'm also doing a series of 4 webinars on the Building Safety Act. And I will be dealing with some Building Safety Act issues today because there's a question arisen in that connection. As far as housekeeping is concerned, those of you that are new to this, we're here to talk about any topics that you've got. I normally take the lead with some issues that have come across my desk or people that have asked about or people that have raised as issues to be discussed in the forum. And after that, we go wherever we wish. Invariably, we'll come back at some stage to the Building Safety Act. That's the way it seems to work at the moment. But again, anything that you want to talk about, any burning issues that you have, please let us know. Interestingly, because of the popularity of the forum, Robert and I are getting contacts from various different organizations, different entities who are wanting to participate. So, software companies, all manner of different things are saying, hey, we're interested. And what we'll do is we'll invite them along from time to time, not for a sales pitch, but to discuss issues relevant to the product. So if anyone has any ideas relating to that, hey, that's would be welcome and well received. So normal thing with slides, useful websites, do have a look at all of those sites. I was looking recently at the Leasehold Advisory Service website, some interesting new stuff on there. Also some interesting stuff on the Leasehold Knowledge Partnership too. 3 stone buildings, that's just referring to a co-ownership questionnaire. You probably all use co-ownership questionnaires in any event. So we'll skip on to that and let's have a look at my starting points today. The first thing I want to talk about is a case that I spent some time over at the weekend, a case called Weaver against Smith. 2023 decision concerning some farming land in Wales and a very interesting case concerning rights of way. And the reason I mention it is there's some interesting principles that I want to share with you as a starting point today. Point number 1 with regard to this case, you had a description of the right of way within a deed. You also had a deed plan. The description of the right of way referred to the fact that this was an access to a farm. The plan that accompanied the deed and was annexed to the deed showed the right of way, shown coloured yellow, but was incomplete in that the yellow line didn't extend to the highway. Meaning that if we looked at the plan, the right of way finished in an adjoining farmer's yard. And if we looked at the description of the easement of the right of way in the deed itself, there was a reference to an access way for particular agricultural purposes for the farm over the adjoining farm to the highway. So the court had to have a look at this to decide just what this meant. The owner of the servient land was being awkward and basically saying, no, you don't have a right of way through my yard. And the owner of the land that was the dominant land apparently was saying, no, the obvious thing here is that this is a right of way to my farm. It is of no use whatsoever to me unless it attaches to the highway. So, number of things. First of all, importantly, this case highlights the need to be careful about how we word easements generally and rights of way in particular. The fact that this was called an access way was a very important point from the judge's perspective, on the basis it revealed what was intended when this easement was created. It was a way for access to the dominant land. The second thing that was important was that the easement referred to the fact that the right of way ran through a gateway, and that the right also extended to enable the gate to be opened, provided the gate was closed. And again, that was another factor. On the yellow track, as per the plan, there wasn't a gate. If the claimant was right with regard to the right of way, then there was a gate that was on part of the right of way that was part of the farmyard. So again, that was an issue for the court as well. So highlighting 2 points: one, make sure your plan is consistent with your deed, and two, make sure the deed clarifies precisely the extent of the way, referring to points A and B as start and end of the right of way, or physical features at the start and at the end of the way as well. Interestingly, this wasn't a case where there was any disputes or issues with regard to repair and maintenance. It was purely and simply the physical extent of the way. Now, the other thing that was really interesting was how the court dealt with the issue of construction. In other words, how would the right of way be interpreted? And what the court did was referred to another case, and I'll just give you the name of that case because it's so important. Don't know whether you've seen it. ABC Electrification Limited against Network Rail Infrastructure, a 2020 decision, which was a Supreme Court, it was a Court of Appeal decision, I think, but reviewed some of the Supreme Court decisions that occurred previously. And what the court said, and I'll just read this to you because it's really interesting. When interpreting any form of written contract, the court is concerned to identify the intention of the parties by reference to what a reasonable person having all the background knowledge would have been available to the parties would have understood them to be, using the language in the contract to mean. It does so by focusing on the meaning of relevant words in their documentary, factual, and commercial context. That meaning has to be assessed in the light of the natural and ordinary meaning of the clause, any of the relevant provisions of the contract, and the overall purpose of the clause and the contract. So the judge was saying, if I'm dealing with a right of way that refers to an access way, then there presumably has to be some form of reasonable access. And reasonable access in the context of this particular right of way meant access to the farm, to the public highway. The other thing that was said, which was really interesting in this judgment, was looking at the fact this easement has been registered. Remember, any legal easement must be registered. And the judge said that when I'm interpreting a right of way, when I'm referring to a deed of easement, it's important to understand that I'm going to give more weight to documents that have been submitted to the land registry on the basis that these documents are in the public domain and are understood by lawyers and presumably clients too to be in the public domain. And the judge emphasised the fact that therefore he would attach more weight to what had been submitted to the land registry, and also emphasised the fact that where documents haven't been submitted to the land registry, they will have less weight attached to them in attempting to adopt the rules relating to construction. So we're getting loads of more people joining us today. Thanks everyone for joining us. We're just talking about a case called Weaver against Smith, 2023 decision, a decision in the High Court in connection with 2 Welsh farms. And it's really interesting, and it highlights the importance of, when you're creating a right of way, to make sure that the description of the way is precise, so that in essence the plan is merely sort of providing a visual aid with regard to how the right of way is described. Because in this particular case, the plan showed the right of way ending in a farmyard rather than adjoining or joining onto or attaching to the public highway. So really interesting case. Have a look at it. I've done a full report on it in Property Law UK, which comes out tomorrow. If anyone's really interested and they twist my arm, I'll happily send them a copy of my law report or case report relating to it. The next thing I want to talk about is the Building Safety Act. And I've just been, surprise, and I've just been doing some work yesterday and today on this. And there's two important things to tell you about before I go any further. One, I had a meeting with the Department of Levelling Up yesterday about the Building Safety Act, more on that in a moment or two. And I also had a meeting with Andrew Butler, KC, this morning. He and I are writing a book on the Building Safety Act, along with a number of other barristers in Tanfield Chambers. And he was saying to me this morning that they're beginning to see quite a bit of litigation concerning interpretation of the Building Safety Act. So do watch out for that. Anyway, the thing I want to mention here is a point that I've been bleating on about for ages. The Building Safety Act covers, yes, transactional work, landlord certificates, leaseholder deeds of certificate, relevant buildings, qualifying leases, and Schedule 8 protection. Covers all of that, I agree. But it also covers lots of other things, like the fact that every new property that's built must be subject to a new build warranty. The fact that the Defective Premises Act has limitation periods extended. The fact that when you're dealing with higher risk buildings, more than 7 stories, more than 18 metres in height, there's a whole raft of additional building regulations, a whole raft of additional documentation that you will be seeing and dealing with. Zara, I agree, the new homes warranties are just a complete waste of time, but it's important to understand if you're acting for a developer, they've got to be produced. And if you're acting on behalf of a buyer, you've got to understand, as Zara was saying, that you're going to get them, but you're also going to have to tell the client about their limitations. So anyway, going back then, the Building Safety Act, you've got new build warranties. You've got in higher risk buildings, higher than 18 metres, higher than 7 stories, issues with regard to additional responsibility for landlords and accountable persons with regard to the documentation that they've got to produce during the building's construction. And here's the important point: there are also a whole raft of additional documents that are required once the building becomes into occupation, described as a golden thread of documents. There's an interesting article in the Estates Gazette just recently about higher risk buildings and just how wide-ranging the law is relating to them. And remember, some of the law was introduced or became introduced on the 1st of October. There are still parts of the Building Safety Act that aren't law yet. But the important thing for practitioners to understand and appreciate is that if a building is more than 18 metres in height or more than 7 stories in height, it is a higher risk building. If there are more than 2 residential dwellings within it, it needs registering. The Building Safety Act implies, courtesy of amendment to the Landlord and Tenant Act 1985, implies covenants in the lease that potentially burden leaseholders and certainly burden landlords. So do be alive to all of that. You've got to be careful when you're reporting on title. If you're dealing with leasehold property that involves the Building Safety Act, you've got to be careful if your building is more than 18 metres in height or more than 7 stories in height. In addition to the Schedule 8 landlord certificate, leaseholder deed of certificate issue, which we're going to come on to, you've also got to be aware of the additional provisions that the Building Safety Act create in connection with higher risk buildings. The next point that I want to touch on is something that I've been sort of working on recently. I've just been reviewing the 2 chapters that I've written in the book about how the Building Safety Act impacts on transactional property lawyers where a building exceeds 5 stories or exceeds 11 metres in height. And there are some very important points that I want you to understand and to appreciate. Point number 1, it is not necessary for a seller to serve a leaseholder deed of certificate on the landlord. The only time that that is necessary, in accordance with the Act, is where the landlord asks for it. And where the landlord asks for it, you have 8 weeks to produce it. Those 8 weeks can be extended to a further 4 weeks by a request by leaseholder. So again, I have been bombarded over recent times, and indeed from when the Building Safety Act became an issue, with practitioners saying to me, what do I do about serving the leaseholder deed of certificate on the landlord? I repeat, only if the landlord requests it is it necessary for the landlord to be provided with it. Now, two things that are important here. As far as the leaseholder deed of certificate is concerned, it is a golden ticket for the buyer, okay? Because it is confirmation from the leaseholder, subject to some caveats, that this lease is a qualifying lease. But where you were to serve a leaseholder deed of certificate voluntarily on a landlord, if you're acting for the seller, you're potentially weakening the position of the buyer. The next point that I think is important, and again it's emphasis. There is an inherent danger if you're acting for a seller in asking the landlord to produce a landlord certificate. A leaseholder selling a flat or apartment is obliged to notify the landlord of their intention to sell. A leaseholder can at any time ask a landlord for a landlord certificate. But in circumstances where the landlord should have produced a certificate, but who fails to do so within the 4-week prescribed time limit, so where landlord should have produced a landlord certificate but hasn't, then the leaseholder seller and subsequent buyers become even more protected than if circumstances where a landlord certificate is issued. So I'll just say that again then, right? Landlord certificates, okay, there are steps where in the process where a landlord has to issue a landlord certificate, but if a landlord should issue a certificate but fails to do so or is not prepared to do so, if I'm a seller or if I'm a buyer, I'm not going to bleat and I'm not going to send reminders. All I'm going to do is just sit back with my fingers crossed that the 4-week period expires. In doing that, without a landlord certificate being produced where it should have been produced, the leaseholder, if the building is a relevant building, is going to be protected in connection with historical remediation work or costs that predates the date that the certificate should have been produced. So I frequently encounter, I had an email on this very point this morning, I frequently encounter situations where the buyer or seller is saying to me, my landlord isn't produced to my landlord hasn't produced a landlord certificate. And therefore I'm reminding them, I'm telling them they've got to do it, etc. And my view is I wouldn't do that. Okay, I just wouldn't do it. My problem is that a lot of lenders are still insisting that landlord certificates are produced. So I can understand why you, if you're acting for a buyer, are on the warpath on the basis that you need a landlord certificate in order to satisfy a lender requirement. But I repeat, if a landlord should issue a certificate and fails to do so within a 4-week period, that generates greater protection for the leaseholder buyer. Now, a question that was put very kindly by an attendee today was a question about additional inquiries that should be raised by a buyer in connection with the TA7 form. And I think the TA7 is defective in a number of different ways. But what I'll do is just focus in on the question that's been put to me and the advice that's being sought. I think if you're acting for a buyer, there are some important questions that you should be asking the seller, really harking back to those points that I just made a little earlier. So point number 1, I think, as an additional inquiry would be, has the landlord requested from you a leaseholder deed of certificate? And if so, when? I would also ask, has the landlord been provided with a leaseholder deed of certificate by you? And if so, when? The other, excuse me, the other additional inquiries I would raise concerns a landlord certificate. And I would be asking the seller, can you confirm to me the date that you requested or you notified the landlord of your intention to sell? Now, I was talking to the government department about this yesterday, about this issue of notification. And of course, the Act says notification, but no detail as to what notification means. I think for our purposes, notification could be simply a verbal communication between leaseholder and landlord, but common sense would suggest that the request is made in writing, email, rather than hard copy sort of correspondence or with wet with wet signature, etc. So, when did you notify the landlord of your intention to sell? Please provide me with evidence. What response have you had from the landlord? And can you confirm to me when the 4-week period in connection with landlord's requirement to respond expires? I think they're the key questions that I want to ask. Now, let me just explain why that is so important. Again, in discussing this with the government department yesterday, for once we were singing from the same hymn sheet. My attitude with regard to a leaseholder deed of certificate is the first 4 elements of the leaseholder deed of certificate. Is this a relevant lease? Is it a long lease? Was the lease granted before the 14th of February 2022? Does the lease include an obligation on the leaseholder to pay service charge? We can answer that by looking at the lease. The problem is the question relating to ownership or occupation as of the 14th of February 2022. Now, again, I draw everyone's attention to paragraph 13 of Schedule 8, which states that there is a presumption that the lease is a qualifying lease, provided the first 3 conditions apply: long lease, granted before the 14th of February 2022, and containing an obligation on leaseholder to pay service charge. If we've got those 3 in the bag, then provided we can show that the landlord does not possess a landlord certificate. Hi, Megan. Megan, I've just dealt with your question. We have recorded it, so you'll be able to see it, or you can send me an email and I'll go back and deal with it in a moment or two. Zara, there's loads of questions coming up. I'm going to deal with all those questions when I finish this point, if that's all right with everyone. Going back to paragraph 13 of Schedule 8, as long as I can show this is a residential long lease, as long as I can show it was granted before the 14th of February 2022, provided I can show that there's an obligation in the lease for the leaseholder to pay service charge, then I have a qualifying lease. If I can show that the landlord does not possess a leaseholder deed of certificate and the landlord has not taken the prescribed steps or reasonable steps to obtain that certificate. So my additional inquiries for Megan's benefit are: 1, I want the seller to tell me when they've notified the landlord of their intention to sell. And I want to know from the seller whether the landlord has responded within the 4-week period or not to that request. I would also want a seller leaseholder to tell me if they've asked at any point for the landlord to produce a landlord certificate. And then I also want to know whether or not the landlord has asked for or been provided with a leaseholder deed of certificate. And I repeat, where you're acting for a buyer and subject to your lender's instructions, your client is in a better position where a landlord should have produced the certificate and hasn't produced a certificate, and in circumstances where the seller has a valid leaseholder deed of certificate that hasn't been asked for nor provided to the landlord. Okay, let's have a look at the questions relating to this. Right, let's just go up and have a look at all of these. Hey, brilliant. Thank you, everyone. Right. So, first of all, okay. New build warrant is not, yes, Zara, I agree, but you've got to understand now that the Building Safety Act requires any builder, even if they're building one unit, to provide new build warranties relating to it. Sean, yeah, happy to provide a copy of Weaver and Smith. No problem with that at all. I'll make sure that's made available to everyone. Anyone that hasn't seen Property Law UK, we publish it every month. And this month I did a question and answer session with Howden Insurance Brokers a while ago. Don't know if anyone attended. My dear friend Jenny Screech from Howden attended too, and we dealt with a load of Q&A questions on the Building Safety Act, and a transcript of the questions and answers is in the Property Law UK October edition, if anyone's interested. Right, Zara, someone told me the other day to wear this. Yeah, on any buildings which is 3 stories or more. Yeah, Zara, I'm hearing all sorts of things. Okay, I'm seeing some people are just saying we're not touching residential leaseholds at all. Okay, so I get that. Sue, yeah, not a problem. Zara, this is the interesting thing, right? If you look at the Act, there is nowhere that compels a leaseholder to volunteer the leaseholder deed of certificate to the landlord. Okay? If a landlord requests it, Zara, you're quite right, then the whole aim is that the landlord makes a request to see a leaseholder deed of certificate. So as far as good management is concerned, the landlord can determine that what number of qualifying leases he's got in his building. Yes, Zara, sorry about that. Good to hear from you. Carry on. I hope we've got your microphone on. I'm hoping we can do that. Zara, can we do that? Yeah, Zara, again, I would say, while I'm waiting for you, leaseholders or landlords are issuing disclaimers. If landlords are issuing a landlord certificate with a whole raft of disclaimers, they're doing that because the Association of Residential Managing Agents are suggesting that is good policy. So again, that's why. Now, the interesting thing is I'm not sure to what extent a disclaimer will hold up. I think that's one of the things that's going to go before first tier tribunal relatively swiftly. If we can make sure that Zara's microphone is turned on, that'd be great. Meantime, until I hear from Zara, I'm just going to press on with the questions.
Her mic should be working now, Ian.
All right, thank you, Robert. Hi, Zara. Can you hear us and can you join? Let's have a look. See if we can get her. If we can't, Zara, I'm sorry, I'm trying my best to allow you access. While we're waiting still, I'm just going to have a look at some other questions. Zara, your Sam Smith and Lady Gaga question is somewhere in the ether. I'll tell you what I'll do. I've got a quiet day tomorrow. I will give Sam Smith and Lady Gaga my undivided attention, and I will share with delegates today both the question, if I may, Zara, and the answer. Sure. Zara, you're with us. Yes. Thank goodness. Right, go on, fire away, my friend.
So basically, yes, I thought the whole point of the leaseholder deed of certificate was to establish the protection.
Yeah.
If you are qualifying leaseholders, why wouldn't you serve it?
Mm-hmm. The reason you wouldn't serve it, Zara, is because you'd lose the protection that paragraph 13 provides to the buyer with regard to the owner occupation issue in the leaseholder deed of certificate. So if I can show that a landlord hasn't got a leaseholder deed of certificate and hasn't asked for a leaseholder deed of certificate, then as long as my flat or apartment is in a relevant building, I have a qualifying lease by default, and therefore the Schedule 8 protection. And be aware, everyone, that Schedule 8 protection isn't blanket protection, applies. Now, I've had that now from a KC, I've had it from 6 different independent sets of counsel, and I had it from the Department of Levelling Up yesterday. It's quite clear in my mind that if you're really worried about whether or not we can verify what the producer of the leaseholder deed of certificate is telling us about the ownership occupation point as of the 14th of February 2022, we can walk round it. Now, Zara, you're right. A landlord should be asking to see leaseholder deeds of certificate, because the landlord is then going to know how many qualifying leases are in the building and how many aren't. Okay.
I'm just confused about how you would lose that protection, though.
Well,
because that's what the whole point of that certificate was, to establish the protection.
Yeah. I wholeheartedly agree, Zara, but have a look at paragraph 13 of Schedule 8, and it's quite clear that that is designed to mean a buyer doesn't have to worry about ownership or occupation. Now, Zara, the interesting thing is, if you're not selling the flat, okay, you can volunteer your leaseholder deed of certificate to the landlord if that's what you want to do. But if you are selling it, my view is, and everyone I've spoken to that has sort of examined this view, is that you create a weaker position for the buyer if a leaseholder deed of certificate is served on the landlord. Great question, though, Zara. Anyway, right, let's look at more of Zara's questions. Yeah. How is a new leaseholder then going to prove that a landlord is not entitled to claim if they didn't have a starting point? Well, the point there is your golden ticket, Zara, is your leaseholder deed of certificate that contains the correct information and has been executed as a deed by the seller. And it doesn't matter, you see, it doesn't matter whether you've served that on the landlord or not. There are issues about the validity of the leaseholder deed of certificate, but if a landlord receives it and the leaseholder deed of certificate is defective or wrongly executed, then you're high and dry anyway. Right. Okay, now Zara asks another question. How would you document the 4-week period for our files who had no idea of the expiry date after service of the leaseholder deed of certificate? Well, again, Zara, unfortunately, the Act doesn't make it clear about how the 4-week period begins and ends. So what I would do is, when I'm notifying the landlord of my intention to sell, I would give them that notice and I would say the 4-week period for reply begins on, and if I'm sending an email, I might say today, or I might say tomorrow as the next working day, and then calculate 4 weeks from that and put that in my note. And then there can be no argument that I've given the landlord 4 weeks notice, and then I've also got details that I can diarise to confirm when that date expires. Appen, hi Appen, we've got a question from you, right? Thank you for this. Zara, if there's any other questions, we'll come back and deal with them. I see there is another question. Right, if a landlord fails to provide the certificate within 4 weeks period, but produce it thereafter, well, you don't need to decline or accept it, Appen. You don't need to do anything, okay? The Act is quite clear that the landlord must respond within 4 weeks. Now, last night I had an email from a landlord who said, I need to produce a landlord certificate. My solicitors can't help me with regard to what it needs to contain. What do I do? And I can understand the predicament. There's a load of information that needs to go in the landlord certificate, and the landlord is scrabbling around trying to find it. The big problem for this landlord, in the email that I got last night, is that there's the landlord. There are also accountable persons responsible for repair and maintenance of some of the common parts in the block. So the landlord's having to ask them to provide information to go in the landlord certificate, and he's not going to get it in time. If he doesn't produce it in 4 weeks, he's had it. Importantly, he's had it with regard to remediation work for relevant defects that arose before the date of the certificate. If he gets a surveyor in tomorrow who says there's some new work that I've just identified that needs doing, the landlord can produce a new certificate relating to those works. Okay? So, Appen, let's have a look. So you're not going to decline to accept it or do anything. You're just going to say it's not valid because it's outside the 4-week period. Okay? Do we need to put the landlord that 4 weeks have expired and that will not accept? No, you don't. Again, under the Act. I think what you're doing is, again, being reasonable when you're giving the landlord notice that you want a certificate, or you're notifying the landlord of your client's intention to sell. You're saying, this is the date that I'm deeming that you've received the notice, and the 4 weeks expires on that date. I don't think you have to do it, but I think in doing that, you're making it clear what your time frame is, what the landlord's time frame is, that hopefully would prevent misunderstanding or problem at some point in the future. All right, now, Zara, great question. Let's have a look. I'll just go back to this one. Right, right, Zara, what about where you have joint owners? How do you identify the 3 properties? One of them may not own more than 3 properties. Well, I was just looking at this, Zara, and I think the position is that if one of them meets the criteria so that he can offer a qualifying lease, he or she can sign the leaseholder deed of certificate. Now, I'm going to check that, Zara, but from memory, and as I say, my head is whirring with the Building Safety Act at the moment, having had my first meeting concerning it at 8 o'clock this morning. But I think that's the position. Okay. Right. No problem, Megan. No problem. Zara. Yeah. When serving a leaseholder deed of certificate, Zara, when it's requested by the landlord. I repeat, you don't have to voluntarily serve a leaseholder deed of certificate on the landlord. Now, I'm quite adamant about this because I've had, as I say, KC, junior councils, and the government all confirming the same thing. Zara, I think your microphone should be on again.
Hi, Ian. I'm absolutely confused.
Please don't be.
So you're basically saying where the Properties Building Safety Act affected, not to serve the leaseholder's deed of certificate, but to ask the landlord for theirs.
Yeah.
And if they don't answer, then you're automatically protected.
Yes. Yeah. Now,
whether or
just
not
so that
you are
we know,
qualifying,
Zara, right?
Yeah.
Zara, can I just say, what you've got to understand is what I'm saying is relating to the Schedule 8 protection, okay? There are other aspects of the Building Safety Act that will apply to the building, whether you serve a landlord certificate or a leaseholder deed of certificate is irrelevant. Those two certificates and the procedure that we're talking about only apply for Schedule 8 protection. And remember, Schedule 8 protection is not blanket protection for all remediation work. It's only protection for remediation costs relating to remediation work for relevant defects. So a lot of people are saying to me, oh, it's so important that I have a leaseholder deed of certificate, that I have a landlord certificate, because Schedule 8 is so critical. I don't think Schedule 8 is all that critical. It's important, but not critical as far as the transaction is concerned. Okay, right. So yeah, you're only obliged, you're only compelled to serve a leaseholder deed of certificate where the landlord says, I want a leaseholder deed of certificate from you. You can volunteer it at any time. If you're not selling the flat and you want to be cooperative with the landlord, then hey, I don't have a problem with you serving a leaseholder deed of certificate on the landlord. But what worries me is where a buyer's going to be relying on the leaseholder deed of certificate and a buyer's concerned about ownership or occupation on the 14th of February 2022, the only way to get rid of that problem is to go down the Schedule 8 paragraph 13 route. Schedule 8 paragraph 13 is designed so that a buyer doesn't have to worry about verification of ownership or occupation as of the 14th of February 2022. Right, okay. Sean, you're saying you're intrigued. I'm interested to know what you're intrigued about. Put something in the chat for that. Yeah, Zara, leaseholders are doing the certificates themselves, okay? Important point here, that's fine. If a leaseholder wants to do that, if you're acting for the seller, you just got to warn the client, look, this is an important document. If you get it wrong, if you get it wrong with regard to content or information it contains, or you get it wrong with regard to procedural issues with regard to execution, and the document is invalid, you potentially could be sued by the buyer, and you could be sued by subsequent owners potentially for misrepresentation. And Zara, you're right. Yeah, UK Finance are asking for both certificates. Again, I was talking to the Department of Levelling Up yesterday, and I was saying you've got to get the message to lenders that paragraph 13, Schedule 8 means that ownership or occupation as of the 14th of February isn't as important as ascertaining what the landlord has or doesn't have with regard to the leaseholder deed of certificate. But where UK Finance are asking for both certificates, then that blows out of the water the point that I've just made and that Zara was sort of challenging there. Okay, Mark. Hi, Mark. Right, so if the leaseholder deed of certificate states the lease wasn't a qualifying lease, does it become a qualifying lease if the landlord hasn't requested a copy? Great question, Mark. the situation with regard to the answer to that is as follows. Where a landlord has undertaken remediation work in connection with relevant defects and should have served a landlord certificate and hasn't served a landlord certificate, then any lease in a relevant building becomes a qualifying lease by default in connection with that work. Okay? As far as the leaseholder deed of certificate is concerned, the issue, Mark, isn't quite as simple as you put it in your sort of last point. The situation is that if I can show that the landlord hasn't asked for a leaseholder deed of certificate, having been notified of an intention to sell or having been asked for a landlord certificate from a leaseholder, then the situation is that the landlord is deemed to be dealing with a qualifying lease in connection with those historical remediation works. Again, Mark, I think the important thing is the landlord certificate is not a one-hit opportunity, okay? I can, as a landlord, serve landlord certificate after landlord certificate if I discover new remediation work for relevant defects. I can't serve a landlord certificate for historical remediation work if there was a situation where a landlord certificate should have been produced and wasn't. Right, okay. Hi, Megan. Let's have a look at your question. Yes, the definition says a tenant, not both tenants. So if one, exactly, Megan, that's such an important point. And again, I had that confirmed to me yesterday. The secret is who produces the certificate. If the person that produces the certificate meets the criteria in section 119D, I think it is, or whatever it is, then you get the protection, don't you? Well done. Christopher, hi, Christopher. Let's have a look at this. Why does the SPIF form ask if the lease is qualifying? Does this not send? Yeah, how would you answer this question? Okay, well, this is another problem, Christopher, and it sort of flows on from the point that Megan was raising earlier and that Sarah was raising earlier as well. The TA7 forms, I think, and the new section 11 is confusing. Okay, and the first point I would make, Christopher, is you've got to tell a seller client about what the section 11 questions are all about. Okay, and if they're asking the seller to confirm if the lease is qualifying, then what you're doing, I think, is referring the buyer to whatever the leaseholder is saying in the leaseholder deed of certificate. Okay, if you're just being asked, is the lease a qualifying lease, then all you're doing is referring to the content of a leaseholder deed of certificate. If you're being asked about the height of a building, etc., then what you're talking about is this a relevant building, which is a different question. All right, you're Sam Smith, and a while ago, Zara, I'm not going to embarrass myself by reminding people when you asked, but you did pose a brilliant question about Sam Smith and Lady Gaga, nothing to do with music, Sean, but something to do with a scenario where Sam Smith was the landlord and Lady Gaga was the leaseholder from memory. I'll share last time. Oh, there you go. Zara's told you in the next point there. Yeah. Sam's selling his leasehold flat to Lady Gaga. Leasehold served on landlord as part of the conveyancing process. Landlord doesn't provide landlord certificate in the 4 weeks. Fantastic news in those circumstances for Lady Gaga. She goes ahead and buys the flat on the basis that Sam has provided the leaseholder deed of certificate and the qualifying leaseholder. Therefore, shouldn't be charged for cladding remediation. The important thing here, Zara, and the important thing, everyone, is that she shouldn't be charged for cladding remediation that exists or was required prior to the date of certificate. If the landlord finds out at a later date that cladding remediation is required and Lady Gaga has a qualifying lease, she's protected. And the landlord can't transmit the cost for the cladding issue because she has a qualifying lease in a relevant building. If the cladding work had been done by the landlord, this is an interesting point, under Schedule 8 of the Building Safety Act, if the cladding work was done by the landlord, then anyone that had a lease in that building, if it was a relevant building, could not have that cladding cost transmitted to them by way of service charge. Yeah. Right. So what would Lady Gaga have to do in practice say land she's not paying? Would not have a starting point. Right. She would bought the flat and don't have a land. If she didn't pay, would it be a breach of the lease? The lease would have a catch-all clause asking the leaseholder to repair. Right. First things first, Zara. You can't do anything in the lease by any type of clause that circumvents the protection that Schedule 8 provides. There's, I think it's paragraph 14 of Schedule 8 that says you can't do anything to get round things. Okay? And the point is that if she has a dispute with a landlord concerning the application of Schedule 8, then that matter would be dealt with by first-tier tribunal. It would be possible to deal with it by way of written representation. Great question. Christopher, does request for management pack of one landlord or two management company amount to notification of an intention to sell? Probably not, Christopher. Not unless you say in the request that we're notifying you of our intention to sell. It is implicit, and it'd be interesting to see what the decision of a first-tier tribunal would be if it was put. But at this point in time, I would say, to be safe, Christopher, you, in your request, notify, or you do it separately. The only caveat I would attach to that is that I've been looking at some recent decisions of the first-tier tribunal, and what they're saying is, look, they're not saying this directly, but indirectly, the Building Safety Act is badly drafted. What we're going to try and do is, in making our decisions, we're going to try and give effect to the spirit of the Act. And so it could well be that you'd see a first-tier tribunal and say, well, a seller is only ever going to ask for a management pack of a landlord in situations where they are selling, and therefore there is an intention to sell. Let's just go on a little further. Would Lady Garden through other types of pre-existing remediation? Well, Mark, you touch on another interesting point here, okay? You've got to understand that Schedule 8 relates to remediation of relevant defects. Relevant defects being defects that are less than 30 years old, dealing with fire safety measures or measures relating to risk of collapse of the building. So it's quite restrictive in its scope. So she could be liable for other types of pre-existing remediation, because Schedule 8 only applies in those circumstances. So there might be remediation, I don't know, relating to some plumbing work or something of that nature, Mark. Well, Schedule 8 wouldn't apply in that. The only thing I would say is that there are other obligations for higher risk buildings more than 18 metres or 18 metres in height or more than 7 stories. But in my example, that plumbing wouldn't be remediation work caught by Schedule 8, even in those circumstances. Right. Zara, I agree with that. You know, it's saying that the only way we can clarify what the Act says is to litigate is horrendous. Horrendous, right? I can tell you from the horse's mouth yesterday, the Building Safety Act is not being repealed. There will be amending regulations coming in. And the problem with amending regulations, and I had a meeting early this morning and another meeting with Andrew Butler KC at 11 o'clock today, and the message is coming loud and clear from every single direction that the creation of new regulations relating to the Building Safety Act makes a bad job even worse. And again, I'll tell you, the other day I was sitting on a Saturday or Sunday afternoon and I had 3 computer screens on my desk, and each was shared. 2 of them were shared with 3 documents. 1 was shared with 2 documents. So I had 8 documents facing me, looking at an associate of a landlord with regard to Schedule 8 remediation work. And by the time I finished looking at the last set of amending regulations, I couldn't remember what the Act actually said. So I was just going round and round in circles. The more amending regs we get, the worse it's going to become. Okay, so have we finished with the Building Safety Act for the day, or does anyone have any other points? Okay, we've got, I think we now know why Zara chose Lady Gaga and John, whoever it was. We've got that because she couldn't think of anyone else. That's fine. Right. Is it probably best not to touch this stuff? Zara, your insurers are saying, subject to certain restraints and constraints. I don't know, have I shared with you what Howden gave me a list of things that they would look for you to do if you're going to take on this work. If I haven't, drop me a note by email and I'll share it with you, because they give me a list of what you do. And basically what they want to know, what insurers want to know, is how many of these types of transactions are you dealing with? What have you got live and what do you envisage? 2, are you triaging work and assessing risk with regard to the Building Safety Act? So sales are less risky than purchases, this sort of thing. Then what you're doing is you're saying, right, am I allocating this work to experienced people? What training have they got, or what training have they done? And then what supervision is in place, given this is specialist work. So there's a whole list of things which I'm happy to share with you. It's a very useful list, to be honest with you. And the other thing is, and again, I meet resistance on this all the time, the government is saying this is specialist work and charge for it. And what I'm saying is, we'd love to charge for it. Conveyancers would love to charge a reasonable amount for the additional work that they're doing and the additional risk that they're carrying, but market forces are such that they can't do it. I mean, you'd think, wouldn't you, given the fact that I think the stats are about 50% of firms are saying I'm not touching this, you think that firms that are saying we will do it could charge a premium, but I'm not seeing that, to be honest with you, which is pretty awful. Okay, has anyone else got any other burning subjects or topics that they'd like to talk about? Yeah, Megan, drop me a note. Just send me an email. I'll put it in the chat box there and I'll share that with everyone. Happy to do that. Just put that in there. Just drop me a note and I'll get it to you. It won't be today, but it'll be sometime over the next few days. And the other thing is, yeah, I did a Q&A with Howden's, and there's a sort of a transcript of that, which you can have a look at as well, too, if you want. Okay, so other issues and other things that are important and worth looking at. One, the Law Society is giving or distributing guidance about the Building Safety Act. It's in draft form. I haven't seen it. I have had people commenting on it. But until I actually see it in draft form, I can't sort of shed any further light on it. But we can get that. Okay, so while I'm waiting for anyone else to fire any questions at me, interesting article, not this week, the week before, in the Estates Gazette about restrictions and notices. I don't know if you saw it. My one comment would be that, remember, agreed notices don't necessarily require the agreement of the registered proprietor. You can lodge an agreed notice as long as you can provide the land registry with sufficient evidence as to your client's interest in land. And something I've just been speaking to practitioners about, I don't know if I've shared this with you, but there were 2 cases involving liquidations of developers recently, where because buyers buying off plan had protected the contract with a unilateral notice, the deposit was returned to them. And in both cases, the judge was saying that the reason the deposit could be retained was because the equitable interest to which the deposit attached was protected by notice. And the judges emphasised that where you didn't protect an exchange of contract, then any deposit paid just fell into the liquidation, and the buyers were simply general creditors in the insolvency. Yeah, the accident collapse. I've been reading about this, Zara, and it's horrendous. It is shocking, isn't it? Because it's, I mean, I don't know. I haven't had time to read about it, Zara, but from the snippets that I'm seeing, there was a great deal of mismanagement. Do you think that's a fair comment? And, you know, it seems also that the writing was on the wall about this. And therefore, why should genuine lawyers working hard be left footing the bill. Don't know what everyone else thinks. Zara, what do you think about it? Obviously, it leaves a sour taste, doesn't it?
Yeah, absolutely. But it just beggars belief that all that money got transferred from client without anybody picking it up.
Yeah.
How on earth could they use client monies? That's protected money.
Yes. You think the bank would have some form of red flag, wouldn't you, or something?
Yeah, you would have thought so when the rest of us are trying to do a good job and comply with the rules.
Yeah.
But literally, I put a post up saying, there's no such thing as an honest politician, and so that actually the chap who runs LKP emailed back and said the same about solicitors.
Yeah, it's awful, isn't it? It's awful. Well, yeah, there's also, as you say, there's the psychological damage too. Mark's saying that yeah, assets have been frozen. Well, that's just. I hope it gets sorted. I hope that lawyers aren't left footing the bill, and I hope there aren't clients that are left high and dry either. It's just a real sorry state of affairs. Do you think? I mean, let's widen this, right? What do you think the market's like? What do you think about the volume, the pipeline of business is like at the moment? Do you think that it's going to be buoyant? Do you think most firms are all right, or do you think that this is an indicator that times are going to get hard and going to get harder? What do people think about that? And again, I'll come at this from a peculiar angle, but I see practitioners that are busy, really busy. Now, I don't know whether that's because firms have laid off staff and have cut their cloth, or because the market is busy, but certainly May, June time, I saw a sort of dip in the marketplace and the dip in instructions, etc. And post sort of September onwards, I'm not getting people telling me that they're struggling with regard to work, etc. Yeah, Megan, I think that's the point, isn't it? With resi conveyancing, there's always a base level of work that you're always going to get. So to an extent, we're protected, aren't we? Unlike commercial lawyers, I think, well, the last recession, I remember I used to do boatloads and boatloads of work for commercial firms up in Glasgow that had English lawyers doing work for Irish investors, and their businesses were just blown to bits in the last recession. There wasn't a base level of work for them to do at all. But resi, I think we don't see the boom that commercial does, but equally we don't see the bust either. Yeah, I agree with that, Megan. Yeah, people always still need to move, and there's always a base level of work. So what about sort of new instructions, etc.? Are you seeing work coming in? Are you seeing work dropping off at the moment? Obviously, we're now getting people getting interested for Christmas. Did you see there was a firm that was offering they were requiring a premium fee if you wanted to move and complete before Christmas, but the firm was saying that they would reimburse you for the premium that you paid if they were unable to complete. Did you see that? I think it was on LinkedIn. All right, thanks, Zara. And so, Sean, yeah, so you're quite busy, yeah. I mean, what about that as a good idea? I mean, I saw years ago a firm that would offer a client a discount on fees if they would complete on a day other than a Friday. And there was another firm I used to do some consultancy work for, and they used to charge a premium if you wanted to complete on a Friday, and an extra premium if you wanted to complete on a Friday before a bank holiday. Yeah, Axiom liquidation. Thanks, Christopher. Long-term cost neutral. Okay, yeah. I think that's fair. And I don't think we're sort of as mad as we used to be with regard to work, but that's got to be good news, isn't it? I mean, there's no way you could sustain the levels of work that we had sort of post-COVID. During the SDLT holiday and things. That was just madness. So if work is sort of nice and steady, that has to be good news. It is. It's like all of these things. Time after absolute. Are they, Zara? Another SDLT holiday? Wow. Suppose, yeah, that could be in the offing. It's 1:30, folks. So thank you so much for today. Once again, it's been really good fun. I've got some people lined up to come and talk over the next few webinars. The next one will have someone from the Department of Levelling Up. Zara, you've got to promise me that you'll behave. Zara, okay? Because I've told the person from the Department of Levelling Up that they need to wear a suit of armour. and they'll probably need counselling afterwards. But Zara, thank you for that. I'm comforted by the fact that you behave. I knew you would anyway. It's brilliant. Thank you, everyone. I've really enjoyed it. Hey, tell people you know about this event. Fire away. If you're working and something hits you, or a problem hits you, or something you can never come across, make a note of it, or ping an email across to me, and we'll add it to the list. Yeah. Okay. Brilliant. Thanks, everyone. Great. Robert, thank you very much indeed for organising things and sitting in the background and making sure things work out. We have recorded today, Megan. If you want, so I hope I reiterated what I said before you joined us, but if you missed it, let me know. But there's a recording and you better see. Thanks, Sue. Thanks, Katie. Cheers, Megan. Zara, once again, as always, great help. Thank you. Great contribution. Cheers, Christopher. Stay safe, everyone. Yeah, and speak soon. Thanks, everyone. Bye-bye.